So, the Supreme Court has issued an order in the critical Second Amendment Preservation Act challenge that was pending in front of them. So, let's talk about what happened in this critical case and where it goes from here. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also, double-check to make sure YouTube has not unsubscribed you. As I mentioned in the intro, in this video, we're going to be talking about a significant Second Amendment Preservation Act case that was seeking Supreme Court emergency review. This is a case that is dealing with a state's Second Amendment Preservation Act, also known as a SAPA law. And we've discussed this case before because in the past, the Supreme Court issued an 8-1 order denying an emergency stay which would have protected Missouri SAPA law. This case went back in front of the Supreme Court, and we recently got the court's answer. The Supreme Court, in a recent order list, denied emergency review to this case, and because of that, this case has now been sent back down to the lower courts. And this all happened because the Trump DOJ was pushing back against Supreme Court review of this case. But this case is not yet done. There is still a lot to develop in this challenge. Now, you might remember that in this case, the Trump administration continued to argue that the SAPA law is invalid in some of its applications and that the Supreme Court should deny review to this case. However, at the same time, they also stated that if the court denies review to this case, the government will release some of the judgment that happens, at the lower court level. The Biden administration got some rulings in their favor completely blocking the SAPA law. But here the Trump administration said that if the Supreme Court denies review to this case, they would release some of that judgment. Now, the state of Missouri responded to that by pointing out that the concession made by the Trump DOJ is exactly why the Supreme Court should have granted review to this case, and they should have granted review after it went to conference. But unfortunately, the Supreme Court took the administration's word and ultimately denied review to this case, leaving the door open for the administration to now remove some of the prior complete block on the SAPA law that the Biden administration got down below. Now, this lawsuit revolves around the 2021 Second Amendment Preservation Act that was passed in the state of Missouri. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies like the ATF in their attempts to enforce these federal laws, which the state believes violates the Second Amendment. The law prohibits Mizzou's officers, agents, and government officials from helping federal agents who are attempting to enforce those inconsistent laws. The law also created a civil remedy where anyone in the state of Missouri could sue a Missouri official if they helped to enforce a federal law that the state believes violates the Second Amendment. So the law aimed to give the true enforcement powers to the residents of the state of Missouri instead of the state or any of its officers or agents. Now, in this Missouri case, the district court on review ruled in favor of the then Biden administration and then Biden DOJ, striking down the Missouri Preservation Act entirely. Now, in response to that, the state of Missouri then appealed to the Eighth Circuit. Missouri at that time wanted a temporary stay on that lower court complete block on the SAPA law, and that eventually led them to seek emergency Supreme Court intervention. However, on review, the Supreme Court issued an 8-1 order denying that request for an emergency stay. Only Justice Thomas was in favor of granting the stay and allowing the SAPA law to go into full force in effect while this was litigated. Now, after the Supreme Court denied review to that case, it went back down to the ET Circuit. There was some expedited arguments and briefs that were submitted to the ET Circuit, and the Eighth Circuit ultimately ruled in favor of the federal government, striking down the SAPA law once again entirely. But then once again, Missouri responded by seeking Supreme Court review of that ruling, and they requested a reassert from the Supreme Court. So essentially, they wanted them to review what the lower court said about this Missouri SAPA law. Now, one of the big things that Missouri pointed out was that the ETH Circuit essentially said the structure and potential operation of this law is valid, but they ultimately struck it down because they did not like the underlying Second Amendment purpose. So they did not like that the SAPA law was revolving around the Second Amendment. They said that the way that this law was structured and potentially operates is valid, but, for the purpose of the Second Amendment, it must be struck down. Missouri argued that the Eighth Circuit went against clear precedent and found that state officials could be sued because the court believed that the state played a role in enforcing the law by simply complying with the state law that said that they can't do anything. Essentially, the ETH Circuit found that compliance and not action is still enforcement. Now, this law was originally opposed by the Biden administration, but now the Trump DOJ has controlled the case. And initially, they stalled the response out at the Supreme Court level for multiple months. But then we got the response from the Trump administration, and they continue to argue that the SAPA law is invalid and that the lower court got some of their decision correct. However, at the same time, they argued that if the Supreme Court denied review to this case and it got back in the hands of the lower court, in the hands of the district court, the federal government there, the Trump DOJ, would ultimately dismiss some of the judgment that the prior Biden administration got. They argued in response to the petition that having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the act that do constitute mere non-enforcement of the federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in this pre-enforcement posture about how certain provisions of the act will be applied and about whether the provisions on which the Eighth Circuit focused are indeed inseparable from the rest of the act. They stated that given those concerns, the United States has decided that it would acquiesce in narrowing the scope of the judgment when the district court regains jurisdiction over this case. So after stalling the case for a few months, the Trump DOJ responded by continuing to argue that some of the SAPA law is potentially still valid, but most of it is invalid, and that the Supreme Court should deny review to the case. At the same time, like I mentioned, they also said that once this got down to the lower court because it's still in a pre-enforcement posture, they would release some of the complete block that the Biden administration got. And unfortunately, the Supreme Court sided with the Trump DOJ in this case. In a recent order, the Supreme Court decided to deny emergency review to the SAPA case. Now, that's not completely surprising because when it comes to these kind of interlocutory emergency cases, the track record of the Supreme Court, especially when it comes to Second Amendment cases, is that they avoid them. For the most part, there are some rare occasions like the Wolford case, which was recently granted review by the Supreme Court. But in that case, you actually had the Trump DOJ supporting that challenge, asking for the Supreme Court to take review of the case. But here in the SAPA challenge, it is the United States government that's directly opposing what's happening in Missouri. Now, despite that denial in the case, it's not yet done, and it will still move forward. As the United States stated in their request for denial, once this gets back in the hands of the lower court, they state that they will be releasing the total preliminary injunction that they got against the Missouri SAPA laws. So there may be some ways in which the SAPA law will be able to be implemented or go into effect in some ways as the case moves forward towards a final marriage judgment. So even though the Supreme Court denied emergency review to the case, it will move forward at the lower court level, and we will see whether or not the Trump administration will stay true to their promise and release some of that judgment. So unfortunately, the Supreme Court once again denied review to a critical Second Amendment case, this one dealing with a SAPA law, but there's still hope and positive movement in favor of keeping the Missouri SAPA law in place in some ways, at least while this moves forward to further litigation. So that's what's currently happening in this critical Second Amendment Preservation Act challenge. As we get more information as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. You can also check out one of the 2 videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.